Cisco WebEx and Microsoft Teams. And Mr. Lipkin, you'll capture from the participant list in Zoom who all is participating in the hearing today?
Yes, sir.
Thank you.
Hello.
Good morning, Mr. Lewis.
Good morning. Sorry about that. We had called the yesterday's link.
That's right. And I see you're doing the same thing you did yesterday where you are using a phone for your audio, and which is fine. That seemed to work fine yesterday.
Yes, sir.
And Mr. Lewis, is Ms. Pfeiffer there with you, or is she yet to join us?
I am here, Mr. Hartsfield.
Thank you. Well, I can't tell because your name's not on the participant list, but Mr. Lipkin can capture you for the list of folks who are in attendance.
And Chief Meade is here also.
Thank you. I believe he was there all day yesterday as the city's representative.
Correct.
And my clock shows that it's 9 a.m. Central Time. Mr. Cervantes, are you ready to proceed with your case in chief?
Yes, I am, Mr. Hartsfield.
All right, and I should have alerted the court reporter to be on the record when I asked that. So let me start again. If Mr. Lipkin's on the record, Mr. Cervantes, are you ready to proceed?
Yes, I am, Your Honor.
And Mr. Lewis, are you ready to proceed? And I saw you nod your head. I didn't hear you say yes.
Yes, I am, Your Honor. Sorry about that.
That's quite all right. Then with that, Mr. Cervantes, if you'll call your first witness.
We would call Timothy Gill, and if he could unmute his microphone.
And as I recall from yesterday, Mr. Gill was sworn in when he was called as a witness by the city. So we'll just proceed with the understanding that he's still under oath, and you may proceed with your direct examination of the witness.
All right. Mr. Gill, could you turn to tab 3 of the binder in front of you? And I want to direct your attention to Exhibit 3, which is COSA 000007.
Yes, I have it.
And the question that I have for you regarding Exhibit 3 is, did you have an opportunity to see that before or after you met with Chief Hood when you received the indefinite suspension in this case?
I did not see this document until after I was terminated.
All right. Can you tell the hearing examiner when you would have had the first opportunity to see this document?
Sure. So after my termination, I had to respond to a complaint that was received by the EMS licensing board. And this would have been in late 2007. I had my
2007, 2017.
2017, I'm sorry, late 2017. I had my lawyer request that document, and it was provided to us at that time.
All right. And do you recall yesterday the city attorney asked you several questions about whether you challenged the results in Exhibit 3 at any time before you met with the chief? Do you recall that? You recall being asked those questions?
Yes, I do.
All right. And can you explain whether you challenged the results before you met with the chief? If you did, and why not? Why or why not?
I did not challenge the results before I met with the chief. I had not yet received the results of the test.
All right. And when you met with the chief, not having the test results, did you challenge the test results when you met with him?
No, sir, I did not.
Okay, and why is that?
I didn't have a copy of the test results at the time, so I didn't know what the results with this document showed, and I was told that I wouldn't be given the results by the administration that I spoke to, but it's also, I remember from what the chief said yesterday that I believe that they didn't have the results at the time to show me.
All right. And before the meeting with the chief, do you recall his testimony yesterday that he said that legal representation is not allowed in the meeting? Did you know that before you met with the chief?
Objection is a misstatement of the facts. Did not say legal representation. There's a union rep there and another rep that can sit in.
Well, let me rephrase. You heard the testimony of the chief that he does not allow lawyers to be present to represent employees that appear before him on contemplated suspensions or discipline. Do you recall that testimony?
Yes, sir.
And did you know before meeting with him that he would not permit a lawyer to represent you at that hearing?
Yes, sir, I did.
All right. And before you met with the chief, did you meet with a union representative?
Yes, sir, I did.
And who was that union representative?
Her name is Connie Hall.
And did she give you any advice before the meeting with the chief?
Objection. Question calls for hearsay.
Overruled.
She gave you any advice before you met with the chief?
Yes, initially I was told that that it was going to result in termination. So it was recommended to me to, when I met with the chief, to go in and beg for mercy. And
Objection to hearsay. This Connie person was not listed as a witness, and you can't circumvent the witness rule by asking what someone else told you going into a meeting. I asked for your witnesses so that I could cross-examine anyone. You cannot withhold this person from a witness list and then come in today and say, what did all these other people tell you?
It's not offered for the truth of the matter asserted, but they've made an issue. They made an issue of why he didn't do certain things, and so we wish to explain that, and we're entitled to do that.
I'll overrule the objection and give you some leeway.
All right, and so what did Connie Hall advise you to do?
I was recommended.
Objection. Your Honor, may I have a running, I'm sorry to keep interrupting, but I just want to have a running objection to hearsay on this.
You may have a running objection on this topic.
Thank you. Thank you very much.
Go ahead and answer, please.
So initially, I was told to beg for mercy, and that maybe he would show some leniency. Directly prior to meeting with the chief, I was told that there was no chance to save my job, and that it was the union's position that they recommend that I resign.
Okay. And so when you met with the chief, what do you recall the first thing happening?
The first thing that happened was I met with Chief Carl Weedage and Chief Andrew Estrada. I was told that they had resignation papers ready to sign, and if I chose to, that I was given the opportunity to sign the papers and resign prior to receiving a termination.
All right. And you knew the position of Chief Weedage at the time?
Yes, sir.
Okay. And so when he recommended that you resign, what did you tell them or do?
I respectfully declined, and
What was their reaction?
they were visibly upset that I declined the resignation.
All right. Now, directing your attention to March 2nd, 2015, the day that you were tested for drugs, on that day, did you seek any legal advice?
No, I didn't.
Did you seek any advice from, and I said March 2nd, 2015, did you seek any advice from the union representative before that? This is the first suspension we're talking about in 2015.
Then
No,
I checked, I think you have your dates wrong, and I just want to be clear. March 2nd, 2017 was the date of the second test. So I just want to, I'm a little bit confused and I want to follow along.
Okay, I apologize. So the first time you were tested for drugs and suspended in 2015, that's what I'm talking about, the first time.
No, I didn't have any contact with any union officials.
Or legal advice the first time you were suspended, correct?
That's correct.
All right, and you did accept the 30-day suspension. You admitted to that yesterday, correct?
Yes, sir.
All right, when you accepted the 30-day suspension, did anyone from the San Antonio Fire Department tell you to seek evaluation, education, or treatment to address your use of marijuana?
No, sir.
Did anyone tell you to seek or complete a rehabilitation program as determined by a drug abuse evaluation expert?
No, sir.
Did anyone from the San Antonio Fire Department ask you to report to a drug abuse expert?
No, sir.
Now, you heard testimony yesterday from Chief Weedage about what you may have done in 2015 or 2017. You did admit that you spoke to Dr. Perisher, a chaplain, and someone else, correct?
Yes, I do.
Okay, so to be clear, was that in 2015 or 2017 that you did that?
That was in 2017.
All right. So you never talked to them back in 2015, is that correct?
That's correct.
All right. And in 2015, did you seek treatment before you returned to work in late of May 2015?
No, I did not.
Did anyone in the fire department ask you if you had any documentation that you obtained drug treatment in 2015 before returning to work?
No, they did not.
Um, so given your answer, would it be fair to say that there's no verification of you completing any treatment before returning to work?
Yes, that's fair to say.
All right. And before returning to duty, did you undergo any fitness for duty evaluation?
No, sir, I did not.
And before you returned to work in 2015, did anyone ask you to submit to drug testing?
No, sir, they did not.
Now, I don't know what that is, but let me see if I can stop that noise. Um, Yesterday, there was a discussion about an evidence technician, collection technician, and I believe it was Chief Jimenez, I believe, said that there was tension between you and the technician. Can you tell the hearing examiner whether there was or was not tension?
Yes, sir, there was.
And could you tell us what the whether there was one or more sources of tension between you and the technician?
I had I had a couple I had a few areas of concern.
And can you tell the hearing examiner what the first area of concern that arose between you and the technician?
So the first thing that concerned me was the observed versus unobserved uh, collection that I was being asked to supervise.
And what do you mean by observed versus unobserved?
So initially, I was told by the testing collector that it was to be an observed procedure, in which case I had to, we were both going to step into the restroom. I was going to remove, I was going to have to take down my pants. I had to take down my undergarments far enough down below my knee that they could visibly see my leg, in my thigh area, and that I was to provide the sample while being directly supervised.
All right. And was this a problem for you?
Yes, I believed that it was incorrect. Um, it wasn't what I did the first time in 2015, and in 2015 I was given the privacy to provide the sample.
And so did you let the collection technician know your displeasure with this?
Yes, sir, I did.
And how did he respond?
He became agitated.
And did he say anything to you?
He stated that that was the requirement that I was being given, and that if I didn't consent to that, it would be considered an admission of guilt.
And did you believe that was correct?
I didn't believe that that was correct.
Did you believe that was fair?
No, I did not believe it was fair.
And when that was told to you and you disagreed with it, did you challenge the fairness of this by telling anyone?
It was recommend, I let, at the time it was Chief Hatton know my concerns, and in which case Chief was called to the location.
And did anyone else show up to the location?
Sorry, can you repeat that?
Did anyone else show up to the location?
Just Chief Jimenez.
Okay, but you initially called Chief Hatton?
Yes, Chief Hatton, he's normally stationed at that station
All
at
right.
that all the time.
And so when Chief Jimenez came over, were you ultimately allowed the ability to provide the sample in reasonable privacy?
We sat down and I let him know my concerns. He had part of the guidelines printed out. We talked about it. He showed me what was expected of me and what the guidelines showed, and I was able to give my sample with privacy, and I complied with that, with the order.
All right. And was there another source of confusion when before Chief Jimenez showed up?
Yes, so I was confused as to why I was unable to self-report prior to the test.
All right. And did you attempt to self-report prior to the test?
Yes, sir, I did.
All right. And one final question. Do you recall whether any medical review officer ever called you or discussed the test results with you afterwards?
No, not that I recall.
We pass the witness.
Your Honor, can I take 5 minutes?
You may.
Thank you
So
very
we'll
much.
take a short break.
Thank you.
And Mr. Lewis, your phone is still muted. Mr. Lewis, are you ready to go back on the record?
Yes, I am. Can you hear me now, sir?
Yes, then back on the record. And Mr. Lewis, do you have any cross-examination of the witness?
Yes, sir.
Please begin.
All right. Thank you, Your Honor. Good morning again, Mr. Gill.
Good morning.
All right. I want to run through what you're actually being disciplined for, sir. If you can turn to, and do you have in front of you exhibit number 1?
Yes, sir, I have it.
All right. And let me know when you're there.
I'm there.
All right. And you see, sir, in exhibit 1, it's alleged that you violated Rule 13, subsection C2, C12 of the rules and regulations of the department. You see that?
Yes, sir.
And it lists abide by laws and departmental orders. It lists conduct and behavior. It lists use of intoxicants, and it lists controlled substances. And these are the allegations or the rules that you've been alleged to have violated. Do you understand that?
Yes, sir.
All right. And going back to 2012, or 2015, in 2015, you were also accused of using and smoking marijuana, right?
Yes.
And in 2015, you did not appeal that disciplinary suspension, did you?
No, I did not.
Asked and answered.
And,
It's been
Overruled.
and in 2015, if you can turn to tab number 10 in your binder.
Okay, I'm there.
All right, and in 2015, shown on the exhibit number 10, you were alleged to have violated Rule 13, subsection C2, C12 of the rules and regulations of the department. Do you see that?
I see that.
And you were also alleged that you violated Rule 3.01, conduct and behavior, and Rule 4.09, use of intoxicants, subsection E, narcotics, on or off duty. You see that?
I see that.
So in 2015, you were notified by this disciplinary action that your conduct of using and possessing and smoking marijuana were violations of Rule 3 of conduct and behavior and the use of intoxicants. You see that?
I see that.
And so you were on notice in 2015 that those your actions violated at least those 2 rules. So yes?
Yes.
All right. And so there was no drug or rehab course that would have put you on greater or heightened notice that smoking marijuana was a violation of the department rules, is there?
I don't understand the question.
You know of any drug or rehab course that was going to teach you the rules and regulations of the department?
I don't know.
Okay. But nonetheless, you knew that it was a violation of those 2 rules.
That's what the document says, yes.
You didn't understand the document?
I understood that this document.
Okay, thank you. And so, skipping forward, you did not attend any sort of drug or rehabilitation class after the 2015 discipline, did you?
No, I did not.
Okay. And you proceeded then, once you got back after your 30-day suspension, to work for the department.
Yes, sir.
And you continued working for the department for approximately 2 years until this second marijuana incident occurred, correct?
Correct.
And You're tasked as a firefighter to know the rules and regulations of the department, are you not?
Yes.
Okay. And then in 2017, there was a family member or someone that called in to inform the department that that there was an issue with you and marijuana, correct?
Objection, lack of personal knowledge.
Overruled, the witness can answer whether he knows that or not.
I don't personally know that. I was told by the chief that that's what he had knowledge of.
Okay, fair enough. So you don't actually know who called.
No, sir, I don't.
All right. And so that put in motion a second drug test on March 2nd, 2017, correct?
Objection, lack of personal knowledge.
Overruled.
I don't
you can
know
answer from
what-
your personal knowledge.
I don't know what set in motion the second drug test.
But that's what Chief Hood told you, correct?
That's what Chief Hood stated.
Okay. And so you stated just a few minutes ago that you had some concerns with that second test.
Yes, sir.
And one of your concerns was that, you know, an issue over whether it should be observed or unobserved. Did I hear that right?
That was one concern for the collection process, yes.
Okay. And why did you think that you deserved to have a unobserved test?
That was the process for the first test that I had undergone in 2015.
Okay, did you think that was a contract right of yours or something?
That was my personal knowledge of previous tests.
Okay, and your previous test was a random drug test, just you were drawn and you had to take it, correct?
Yes, that's correct.
All right. And so you're not aware of any sort of contractual reason why you were allowed an observed versus unobserved test?
No, I'm not aware.
Okay. But in any event, Chief Jimenez came and you said that he was explained to you and you were allowed to take the test that you wanted and take it as an unobserved test.
It wasn't necessarily that that's what I wanted. It's just that was what I knew to be the normal as compared to what I had done previously.
Okay, but when Chief Jimenez got there, you were allowed to do the test that you, the unobserved test.
That's correct.
Okay. And so the second point you had was you wanted to, you said self-report.
That's correct.
And who did you voice that to?
I voiced that to the specimen collector as well as my direct supervisor at the time, who was Randall Zamora.
Okay. So you told the specimen collector, I would like to self-report.
In the company of my direct supervisor, Randall Zamora.
All right. You sent a letter to Chief Jimenez, kind of detailing, and it was after the test, and it was kind of detailing some of your concerns about the test process. Do you remember sending that letter?
Yes, I do.
And we have it in this binder. You turn to Exhibit 5. And again, for the record, this would be City Exhibit 5. It's not one of the joint exhibits. And you see down at the bottom, it's labeled COSA 10.
Yes, sir.
All right. And identify in here, in this letter that you sent to Chief Matt Jimenez, where you mentioned that you wanted to self-report.
It's not contained in this letter. I never tried to self-report to Chief Jimenez.
Okay, but you took the time to write a full-page, single-space letter detailing your concerns about this test to Chief Jimenez, and I note in here that you mentioned you didn't want to sign, and you mentioned some other issues, but you never mentioned you wanted to self-report. I just want to make that clear.
That's not contained in the letter.
Right. And so,
However,
But
it is contained on one of the other documents that documented by Lieutenant Randall Zamora.
it's contained in one of the other documents by Randall Zamora. Would you identify that document?
Give me a second. I would point you to COSA document 00008, Exhibit 4, at the bottom of the page.
008. Okay. So, are you saying that's a statement from Lieutenant Zamora?
Yes, sir. It contains his signature.
Okay. And what I'm reading there is firefighter Gill made me aware of need for assistance prior to taking tests and refused test.
Yes, sir.
So unless I'm missing something in that sentence, it doesn't say firefighter Gill told me he wanted to self-report.
I didn't have him dictate exactly what I wanted him to say. He wrote down what his interpretation of it was, I guess. What I told him was that I had a problem and I needed help.
Okay. And why do you think, and what contract clause or what other clause allows you to self-report and get out of a test?
I don't
Are you aware
have
of a contractual right?
I have
I'm
no
sorry. Before you answer, was there an objection, Mr. Cervantes?
No,
All right, then please proceed.
Are you aware of some contractual right?
I wasn't intending to get out of a test, quote unquote. I was intending to self-report and try and get help.
Okay. And you did that once you were in Lieutenant Zamora's presence and the test taker's presence?
Correct.
Okay. And you stated yesterday that when you went in to talk to Chief Hood, you attempted to be. Let me scratch that. You had in your presence at the meeting with Chief Hood a Connie. I don't know who this person is. Can you tell me her name?
Yes, at the time she was a chief. Her name is Connie Hall. I believe at the time she was a battalion chief, and she was also the, as I understand it, the grievance person for the firefighter union.
All right. And if anyone ever tells you to go in and lie, you as a person, are you going to do that, or are you going to tell the truth?
I always intend to tell the truth.
Okay. And so, I'm assuming then that you went in and you told the truth to Chief Hood. All right. And so, when you told Chief Hood that you had used marijuana during your meeting with him after you were given the proposed discipline, were you unaware that using marijuana was a violation of rule of the laws of the state of Texas?
Was I unaware?
Were you aware that using marijuana was against the laws of the United States and the state of Texas?
Yes.
Okay. Just like you were put on notice of that in 2015 because it was one of the violations you were alleged to have violated in 2015.
Yes.
Okay. And were you aware that that in 2015, you're aware that in 2015, smoking marijuana was a violation of the conduct and behavior rule for the department?
asked and answered.
Overruled.
Yes.
Okay. When you went in and had a discussion with Chief Hood in 2017 after you issued the proposed discipline, you as a person, a citizen, and a member of the fire department, you must have known that the use of illegal drugs such as marijuana was a violation of the department rules.
Asked and answered.
Overruled.
Yes.
Okay. And you must have been aware that the use of marijuana was only allowed under the direction of a licensed physician.
Yes.
So you were aware of all of these rules when you went in and you told the truth to Chief Hood.
That's correct.
Sir, don't you think it's important, as Chief Hood noted, to have a drug-free workplace for the San Antonio Fire Department?
Sure. Yes.
All right. And you as a firefighter, you're often involved in situations that can be considered life and death.
Yes, sir.
You drive heavy machinery. I'm not saying you personally, because I don't know your job duties, but the fire department drives heavy machinery often.
Yes.
And you rely on one another to be there to back you up.
Yes, that's correct.
And you want the person next to you to be drug-free.
Yes.
And sir, you were disciplined and issued a 30-day suspension in 2015 for using marijuana. At any point during that 2-year period, did you try to get help yourself?
No, I did not.
Okay. And you knew that, that smoking marijuana could have potential consequences to your career.
As listed in the contract, yes.
Okay, so you know the contract?
Yes.
All right. And so you know that as part of the contract, under section 29(8)(b)(1), that a person who tests positive for marijuana after their first incident is required to seek treatment prior to being returned.
Yes.
All right. And you're saying that the only way you would have ever sought treatment is if the city of San Antonio would have forced you to go.
No, that's not true.
Okay, why didn't you get it then?
Had I been made aware that that was an expectation for me to complete prior to coming back to work, I would have complied and brought them a certificate of completion. At the time, that was not an order that was given to me or stated that that was an expectation of me.
Well, you just said that you knew the contract. So wouldn't you say that it kind of goes both ways?
Yes, it does go both ways.
And wouldn't you say that you were benefited because you received a paycheck for 2 years after coming back to work?
This was asked and answered yesterday.
Sustained.
And at some point, you requested the lab result that's contained in tab 3 or exhibit 3 of the binder in front of you.
Yes, sir.
Okay. And so how did you request that?
The day that I went in to receive my formal termination,
Mhm.
upon receiving the documents that I was expected to sign, I asked, in company of Carl Wiedage and Valerie Frausto, I asked Chief Estrada if I could be provided that document, at which time I was asked by Chief Estrada if I had a lawyer. I responded, yes, sir, I do. At which time Chief Estrada stated to me, let your lawyer handle that.
Okay, so to the best of your knowledge, your lawyer requested this document from the department and it was provided to you or to her.
To
I'm
the
sorry,
best of
I don't mean to say her. I was thinking of Connie Hall. If your lawyer was Mr. Cifuentes, I'll say this document was provided to your attorney.
At the time, Ben Cifuentes was not my attorney.
Either way, your attorney, whoever represented you at the time, requested this document and it was provided to you.
After I was terminated.
Okay. And you're aware that you can request the contents of your personnel file basically at any time?
No, I am not aware.
Okay. All right. We'll pass the witness.
Any redirect?
Give me 15 seconds.
You can certainly have longer.
No, I have nothing further.
All right. Thank you, Mr. Gill. And if you'll remember that the witness rule has been invoked. Thank you, sir. Now, does the appellant have any additional witnesses to call, Mr. Cervantes?
We would rest at this.
All right, so the appellant rests. Does the city have any rebuttal, or do you need a break to decide if you have any rebuttal?
I would like a 10-minute break to decide if we have a rebuttal witness, if we could.
Sure. Let's take, and in fact, given that it's a few minutes before 10 a.m., why don't we just make it in about 15 minutes and come back at 10:10 to give you enough time?
Yes, sir. Thank you very much.
We'll give everyone else an opportunity to take a break as well. So we're off the record.
So we're paused now for the live streaming.
Ah, thank you. Mr. Lewis, are you ready to go back on the record?
Yes, Your Honor.
And Mr. Cervantes?
Yes, Mr. Hartsfield.
Then back on the record, Mr. Lewis, does the city have any rebuttal witnesses to call?
No, Your Honor. No rebuttal witnesses for the city.
All right. And so just to summarize where we are, the city has presented to me all the evidence that it wants me to consider in this matter,
Yes, Your Honor.
and the appellant has submitted all the evidence he wants me to consider in this matter.
That's correct.
In summarizing where we are on exhibits, with respect to city exhibits that were originally labeled as 1, 2, 9, 10, 11, and 12, we relabeled those as joint exhibits 1 through 6, and I admitted those. And I admitted city exhibits 3 through 8 with the understanding that the appellant may come back and tell me that I may not rely upon those exhibits based on appellant's arguments. And I don't have any notation of any appellant exhibits. Is that a correct summary of your understanding of what's occurred with the exhibits, Mr. Lewis?
Yes, it is, Your Honor.
And Mr. Cervantes?
Yes, it is, Mr. Hartsfield.
All right, so as I stated at the beginning, will only rely on the material submitted to me in this hearing for making a decision. And as I recall our initial discussion, the parties are going to submit written closing arguments. Is that still correct, Mr. Lewis?
Yes, sir.
And Mr. Cervantes?
Yes, and as is our custom and anticipating the due dates, it's usually 30 days after receipt of the transcripts, and we notify you when we've received the transcripts. And I guess the issue would be whether you request them by printed copy, or I believe your custom is to receive them by email and Word and PDF.
That's correct. If you'll send them by email as a Word and PDF, that will work for me. And if you folks will just email me and tell me when you receive the transcript, I'll mark my calendar accordingly of when to expect your post-hearing arguments. And if anything occurs that means you folks need additional time, if you'll simply confer and let me know you've reached an agreement to extend that 30 days by whatever the agreement will be, that will be sufficient notice for me. And as I stated at the beginning, I'll send the decision to you via email as a signed PDF. And as I recall the proceedings, my decision is due 30 days after I receive your closing written submissions. Is that correct, Mr. Lewis?
Yes.
And Mr. Cervantes, same understanding?
Correct.
And with respect to your written submissions, if you're going to rely on decisions of any other hearing examiners, you'll need to send me a copy of that decision. If you're relying on a court decision, as long as I can find that in Westlaw or Fast Case or the other service that's available through the state bar, you don't need to give me a copy of the decision. But if you're doing something like a trial court from the state district court, as an example, you would need to give me a copy of those, because I don't believe those are generally available in any of those resources. Is there any other administrative matters that we need to address before we end the hearing? Mr. Lewis, from the city's perspective?
No, Your Honor.
And Mr. Cervantes, from the appellant's perspective?
No, Mr. Hartsfield.
Thanks very much for your time. I appreciate everyone's cooperation and allowing this hearing to go as smoothly as it did. And I was pleased that we didn't have any technical issues that caused any disruptions. So thank you very much and enjoy the rest of your day and the weekend. Thank you. And we are adjourned.
Thank you.
Thank you, sir.
Thank you.
Thank you.
Thank
Thank
you.
you.
Thanks, Ruben.
Okay, take care, guys. Stay safe, ladies and gentlemen.
Bye.
You too.
Say it again.
You're all set if you wanted to
Okay, nothing further needed from me? Once,